A city's plan to expand surveillance, such as through the implementation of flock safety cameras, it's not a partisan political issue, but a fundamental constitutional one that impacts the privacy and civil liberties of every citizen. The debate over these technologies is about protecting the Fourth Amendment, which guarantees the right to be secure against unreasonable searches. Mass surveillance systems erode this foundational principle by collecting vast amounts of data on innocent people without any suspicion of wrongdoing. The deployment of automated license plate readers like flock safety cameras raises serious constitutional questions under the Fourth Amendment. The core issue is whether the government can compile a detailed record of your movements without a warrant. The Fourth Amendment precedent. The Supreme Court has addressed similar technologies in two landmark cases. In United States v. Jones in 2012, the court ruled that attaching a GPS tracker to a car and monitoring its movements for an extended period constitutes a search under the Fourth Amendment and therefore requires a warrant. Similarly, in Carpenter v. United States in 2018, the court extended this protection to cell site location information, finding that tracking a person's movement over an extended period reveals the privacies of life and requires a warrant. Mass ALPR systems function much like the technologies in these cases. They create a time-stamped, searchable record of a vehicle's movements, compiling a detailed digital dossier of an individual's comings and goings. This data can reveal deeply personal information, such as where you work, where you worship, what doctors you visit, which political meetings or protests you attend. The Brennan Center for Justice argues that this creates a data trail that raises serious civil rights and civil liberty concerns. The awareness that your movements are being constantly monitored and recorded can have a chilling effect on personal freedoms and democratic participation. As the Supreme Court noted in Jones, the knowledge that the government is watching chills associational and expressive freedom. The constant gaze of surveillance erodes the freedom to move, assemble, and express oneself without fear of being judged or recorded. Proponents of mass surveillance often claim these systems are for limited purpose, such as catching violent criminals or finding stolen cars. However, history and international examples show a clear pattern of mission creep. In other nations, the infrastructure of surveillance has expanded far beyond its initial stated purpose. In countries like China, the pervasive use of surveillance technologies is used to monitor citizens, enforce social credit systems, and create what one author calls panopticon, where citizens feel a mysterious gaze upon them at all times. The data collected by these systems is often shared with other law enforcement agencies and even private entities without proper judicial oversight. Without a clear and enforceable legal framework, the risk of data abuse and misuse is significant. To effectively oppose the expansion of flock safety cameras, citizens must engage in a multi-pronged, well-researched, and strategic campaign. Research the proposals. First, obtain all public documents related to the city's proposal, understanding the stated purpose, the cost, the data retention policy, and which agencies will have access to the data. Scrutinize the city's justification. Is it based on a specific demonstrated needs or on a vague, general claims of public safety? Again, this is not a partisan issue. Bring together individuals and groups from across the political spectrum who share a concern for civil liberties, from privacy advocates to small government conservatives. Your strength lies in a unified front that transcends traditional divides. This is exactly how they plan to implement this. Launch an awareness campaign to educate your neighbors about the real implications of this technology. Share key facts about the data retention, the potential for misuse, and the legal arguments. Use social media, community meetings, and local news outlets to spread the word. Speak at the City Council meetings, Police Oversight Board meetings, and any other public hearings. Prepare concise, fact-based arguments. Frame your concerns in terms of constitutional rights and potential liabilities for the city. Work with local privacy and civil liberty organizations to draft a model ordinance that can be presented to the City Council. A strong ordinance should mandate that all searches of ALPR data require a warrant based on probable cause. Prohibit the storage of data of innocent people for more than a very short period, if at all. Explicitly forbid the sharing of data with third parties, including other law enforcement agencies or private companies, without a warrant. Require the city to conduct and make public a privacy impact assessment before acquiring any new surveillance technology. This assessment should analyze the technology's potential harm and discriminatory impacts. Consult with other civil liberties lawyers and organizations like the ACLU or EPIC to assess the possibility of legal challenges. The legal landscape is constantly evolving, and a well-crafted lawsuit can be a powerful tool for stopping or reforming these programs. By taking a proactive stance and grounding your arguments in constitutional principles, you can effectively challenge the proposed expansion of mass surveillance and help protect the privacy of your community.